Yo, what is going on? We are back live. I am your host, Dave Spears, a 10 plus year intellectual property attorney, dealing with everything from patents, copyrights, trade secrets, as well as trademarks. So we got a little bit of everything for you guys today. I must admit, man, it's on me. Last week, your boy got a little bougie. Went down to Orlando this past weekend, or last weekend, I should say, and came back. Your boy stayed at the Ritz, so I kind of felt a little bougie. Had a phenomenal time down there. Went to Epcot, did some other things, and came back. And I still had some time to come, but your boy kind of was a little big time. So, man, I apologize for not showing up last Sunday, but we are back. We're gonna try to make this one a pretty quick one. It's a lot of things going on. We got the Sunday night football game. I think that starts at around 8:15, 8:30. And then we have the Tigers. For those of you who don't know, I am in Detroit metro area, the great state of Michigan, and the Tigers are playing Seattle. We're 1-0. So we'll see if we can take a command and 2-0 lead in the best of 5 series. So I think that starts at 8 o'clock. So I'm going to try to get you guys up out of here by 8 o'clock. But we have some cool things. We have a full show for you guys today. We're talking about artificial intelligence. We know what it can do for the business and how that has reshaped the business. We know, I think someone had recently mentioned that it was the first AI musician. We're going to talk a little bit about the first AI actress. So that'll be interesting. We're also going to talk about the interview of the week, which is a banger. Again, we're going to talk about Dame Dash. He's in the league. He's in the news again. This time he's going up against a heavyweight in Balenciaga, so we'll get off into that. Tesla has filed a new patent on a Cybertruck. We'll kind of see what that means for the Cybertruck and the improvements upon thereof. We're going to talk about the interview of the week, whiskey. The whole point of this show is old versus new. And a big part of that is kind of based on the interview of the week where, the old whiskey, old Louisville whiskey versus new Louisville whiskey, that trademark is kind of going back and forth. So we'll kind of talk about that. And the Shark Tank is back. So last week was the first week. I did not do a season 17 episode 1 of Shark Tank, but I am going to do a season 17 episode 2 of Shark Tank. I'm going to give you guys what I thought was the best pitch of the week. So we will talk about that. But before we get off into everything, please hit that like button for the YouTube algorithm, as well as hit that subscribe button to be a part of the IP community. Hey, man, I'm excited about these lives. Sometimes, it's a little interesting, but I am one of the most things I'm excited about this channel is doing these lives, coming to you guys with the kind of the IP recap of the week, as well as kind of doing a live breakdown of the lawsuit. So definitely please hit that like button for the YouTube algorithm, as well as hit that subscribe button to be a part of the IP community. And to the extent that you are watching this, please let me know if you have a question in the comment section. This is probably the only time this week, or forever for the most part, that you're going to be able to give a question to a intellectual property attorney specializing in patents, trademarks, so forth and so on. And your boy billing rate is a little high, man. It's approaching $400 an hour. So to be able to give you that question or answers to that question for free, man, is something that you guys have to take advantage of. So with all that being said, let's kind of start off with the interview of the week. Super Soaker, Lonnie Johnson. I mean, this guy, every once in a while, I'll do a ton of interviews. I try to do a one interview a week. And to be honest with you, with everything that I'm doing on this channel, between the current events, between the lives, between the interviews of the week, the interviews typically take the most time to prepare for, between reaching out, doing the research, doing the actual interview. That typically takes the longest time. And I've done a ton of interviews. I've kind of been doing the Amazon Prime, those kind of that Buy It Now show. I've been interviewing a lot of those people recently. I've also kind of been doing these Shark Tank interviews for a while. And I'm actually going to be in Newport, California for the Shark Tank Reunion Conference. I think that's January 18th through 20th. So I just kind of booked that for the second year in a row. So be on the lookout for that. I'll be there live doing interviews in Newport, California. There's going to be a ton of Shark Tank businesses there that I will be interviewing, so I'm being on the lookout for that. But every once in a while, I kind of do these bangers. And I remember, I think a year or so ago, I did Dan Klitschner, which was, he invented Bop It, the game that we all love, which you say Bop It, twist it, pull it, so forth and so on. And this time I got a chance to interview another big dog, that being Lonnie Johnson, the inventor of the Super Soaker. And not only just the inventor of the Super Soaker, but this guy has invented the Nerf gun. He was a NASA engineer. He's currently the chairman and the founder of Johnson Research and Development that kind of works on solid state technology. So this guy's he's a pretty big deal. I would probably say my number one interview to date. This guy's worth a couple hundred M's, a couple $100 million for those of you who don't know what M's is. And this was something that I appreciated. So let's kind of pull up the interview and see what Lonnie Johnson is talking about as we kind of just play a snippet from that interview. Please go check out that Everything Intellectual Property, the YouTube channel, as well as the podcast. Go check out that interview. But in the meantime, in between time, let's check out what Lonnie Johnson was talking about. Let me make sure I got this thing queued up on the right speed. Yep, I do. Let's go.
Well, my dad was my hero. He was a deacon in our church, and we were in Sunday school every morning. I guess from his military experience, he was very structured. We made sure that when we went to church, our shoes was shined, and so the night before we'd be shining shoes. So just the whole process was, that was his thing. He gave me my first lesson in electronics, and he had spent time in the military, and he knew some basic things about electricity, and he communicated that to me. Whenever he would be repairing the car or doing some project around the house, I was always there watching out of curiosity.
Interview of the week. Welcome to another episode. This is from Lonnie Johnson, the inventor of the Super Soaker. You guys have to go check out that interview. Anytime somebody says that their dad is their hero, man, that's like a soft spot to me. So I'm going to always kind of clip that portion of the interview. And Lonnie Johnson is no different, man. You would imagine that, man, he kind of grew up back in the day, and he was nicknamed a professor growing up. And kind of you have to go check out that interview of what made the neighborhood give him the nickname of the professor. But as you could tell, speaking so fondly of his father, in the I'm not sure if it was the Marine Corps, but definitely in the armed forces. And Lonnie Johnson followed suit. NASA engineer. I think he was in the Air Force, if I'm not mistaken. And hey, man, you can tell his dad very structured. And obviously, Lonnie Johnson had some different plans of his own as it relates to being a NASA engineer, being an inventor, and he's doing some cool things. I think he's based out of Atlanta these days, but shout out to Lonnie Johnson. Please go check out that interview. Like I said, Lonnie Johnson is a big dog. We all had that Super Soaker growing up that made our childhoods great. He invented other things such as the Nerf gun. He was a part of NASA engineer, and he's currently still going strong, man. Johnson Research and Development Lab, working on solid state technologies. And your boy Lonnie Johnson is, man, he's worth a couple hundred M's. So definitely go check out that interview as we move on to the next subject. And that next subject is the Shark Tank. So Shark Tank is back these days, and we kind of pull up here. This is season 17. So Shark Tank has kind of been going strong for a long time. Season 17, episode 2. Your boy, like I said, I was at the Ritz-Carlton, man. I was a little bougie this last weekend, but I'm back now. But I was at the Ritz-Carlton this past weekend. But this weekend, impeccable chicken. I thought that was something that stood out to me out of the four pictures that were on Shark Tank. These were 3 college students, as you see them in a picture. They're pretty much making a protein bar that is essentially kind of chicken. And you can kind of see you have the black pepper. I think you have the orange habanero, and then I think that's like barbecue, whatever, to the right. But, man, these college students, they had the Sharks kind of pretty much in a bidding war. So it's always great when you can go on the Shark Tank and you have the Sharks kind of looking to get your business. They had 5 Sharks. They had 5 offers. They did a deal with not just 1, but 2 Sharks. I think that was Lori and Mr. Wonderful, if I'm not mistaken. And I think these college students are on to something big. It's pretty much something that you can go. We are health conscious these days. And if I tell you one thing, if it's one food that I feel like God has put on this earth for me, it is chicken. I don't care about beef. I don't care about necessarily pork, any of those things, but chicken is one of those things that I love. And they have this, essentially, it's like you go purchase the snack food, and it's almost like a granola bar. You kind of open it up and you can eat it right then and there. They've been killing the game. Like I said, they had all 5 Sharks interested. and they end up doing a deal with not just one but two sharks. So Impeccable Chicken, go check them out. Go check out the full reaction video that I did on Shark Tank, and that one's kind of going crazy. So definitely go check that out. Impeccable Chicken. And one of the things I like about these, the three inventors is one of them actually dropped out. She is from Taiwan, or her parents are from Taiwan. She dropped out of USC to start this business. The other two are from USC. They end up graduating, but they're all pretty young. I would say mid-20s. And they're always like young entrepreneurs because you don't have the responsibility that you're going to have as you get older as it relates to a spouse or kids, whatever the case may be. When you're mid-20s, without kind of kids and a spouse or whatever the case may be, you can take a lot more risk. And it seems like these three entrepreneurs did with Impeccable Chicken. So definitely go check out that. Go check out that reaction video I did. Like I said, that reaction video is kind of going crazy. And I always want to implore you guys to start your business while you are younger. You can still make money and start a business when you're in your 50s and your 60s. However, the best time to start that business is when you are younger. So shouts out to them. As we kind of move on to the next one, your boy Dame Dash is in the news again. CEO, he's this time threatening lawsuit of Balenciaga, and we're going to pull up that interview. Now, I must say, so thankfully, I did a reaction video to this one 3-4 days ago where Dusk and Popperton, which is kind of Dame Dash's family office or his business, they have an Instagram page, but it seems like that Instagram page has been deactivated. And I would imagine that a big part of that deactivation is based on his lawsuit threatening the big guy. Now, sometimes, man, I get it. Y'all feeling good, y'all kind of smoking or drinking or whatever the case may be. Y'all want to kind of pop that stuff on social media. But this time, Dame Dash threatened a big dog. So it's not surprising that his Dusko Popperton Instagram page has been taken down or removed. And I would imagine that a big part of that is based on his lawsuit that he threatened the fashion giant and luxury fashion giant Balenciaga for trademark infringement. But thankfully, your boy had the fact. So let me kind of remove this. Let me pull up what Dame Dash was saying in this Instagram page. Thankfully, man, I was able to capture it. Let's see here. Fight over illegal Dame Dash during lawsuit. So let's kind of tee this up here and kind of see what Dame Dash is talking about. And this one has some commentary for me, so just kind of bear with me. Let's go. Make sure that this is the right one. The right speed, I should say. Okay, here we go. Kind of pull this up. I'm not going to play the volume because it's music, and I don't want to get a copyright strike, but this is what Dame Dash says. Again, Dusko Popperton is, you see the picture of Dame Dash. This is not his personal account, but this is his business account that he runs. He says, I'm flattered, but I do think you're infringing on my trademark. Cease and desist letter. Balenciaga, please tell me who to send this to. I think we can resolve this. Maybe we can collab, but you just can't take my family office trademark. And thanks for bringing that to attention of, I guess, Still Standing CB brought it to the attention of Dame Dash, and he kind of brought it to the attention of social media. Let's see, before we kind of go through these pictures here, let's see what some of the people are saying in the chat. The law offices of ChatGPT. So they're saying that the cease and desist letter was put together by ChatGPT. And I would probably agree with that. Or I won't say I probably would agree with that, but I wouldn't be surprised if this cease and desist letter by Dame Dash, he created by ChatGPT. Like I said, it was missing a lot of things, and it's just read of something that was generated using ChatGPT. But that's neither here nor there. Let's kind of continue to see what Dame Dash is threatening Balenciaga on. That's too far-fetched, I would say. What does Historique says? You don't own the rights to the abbreviated CEO. I would probably agree with Historique as well. And then the last one says people still are defending Balenciaga after they've been involved with child PD. Yeah, look, I ain't gonna get off into that one. But let's read this. Apparently, ChatGPT assisted cease and desist letter. Dear Balenciaga Legal Department, I am Dame Dash, acting on behalf of the Dash Group, the registered owner of the federally protected trademark CEO, covering apparel and international class 25, including but not limited to hats, short socks, sweatpants, so forth and so on. It has come to our attention that Balenciaga is manufacturing, marketing, and selling a variety of apparel and merchandise bearing the word CEO. This unauthorized use constitutes willful trademark infringement under the Lanham Act. Usually that section of the Lanham Act, couple sections. Your infringement creates a likelihood of confusion in the marketplace as to source, sponsorship, or affiliation, damages and dilutes the goodwill of our federally registered
Dame
trademark.
Dash is threatening Balenciaga,
And has
folks.
resulted in a substantial unlawful profits at the expense of the Dash Group. Accordingly, we demand that Balenciaga immediately cease and desist all use of the CEO in connection with any and all apparel, merchandise, and promotional materials. Remove and recall all infringing products from retail, wholesale, and online platforms. Provide a complete accounting of units.
Dame
sold,
Dash
revenues, and
is
profits derived from
threatening
the sale
suit
of
of
all infringing
Balenciaga,
products,
folks.
and remit monetary damages to the Dash Group in an amount of equal to all profits derived from the infringing merchandise and additional damages from the dilution of the trademark and confirming writing within 10 business days. So, I mean, look, I'm gonna tell you this is probably some chat GPT stuff. I've never seen a chat.
I think Dame Dash is
a lot of this stuff is kind of what you
from
see in typical
ChatGPT as well.
in typical cease and desist letters. But a lot of this, I wouldn't be surprised if this was written using ChatGPT. Let's move on here. So this is the shirt this is the shirt here to the right, or this is the shirt that Balenciaga has came up with. CEO, obviously, and we're going to keep going and see what Dame Dash is. He has a trademark CEO, and I do want to kind of bring it back on myself here really quickly because I want to kind of say something here. So Dame Dash, he probably should have went to an intellectual property attorney or at least a trademark attorney to kind of get to him kind of what he can and can't do. So Dame Dash, we all know, has a trademark for CEO. Let me kind of pull that back up in case you guys didn't see it. This is the Dame Dash trademark CEO. And as we saw before, Balenciaga has a shirt that's CEO. This is the Balenciaga sweater that has a CEO on it. Dame Dash has this trademark, and he's trying to threaten and sue against Balenciaga for trademark infringement. However, what Dame Dash doesn't know is he doesn't own the CEO trademark explicitly. He owns this rendition, as you see here, of the CEO trademark, particularly with the, how it's shown here. However, you have other people who have a CEO trademark based on their logo. And what essentially that means is the CEO trademark, the CEO shirt that you see from Balenciaga, that's not a likelihood of confusion in my opinion. And let me know in the chat, do you guys think that this CEO logo is the same as this one that Dame Dash has to the right? Dame Dash threatened Balenciaga with a lawsuit for his CEO trademark. And this is really why I do these lives, because I think Dame Dash is, if he would have went to a trademark attorney, a trademark attorney said, hey, man, I understand what you're trying to say, but you're probably not going to win against Balenciaga as relates to trademark infringement, because number one, it's other people who has a CEO logo that's trademarked. You don't own the exclusive rights to the term CEO, and therefore, I don't think that the CEO logo that Balenciaga has here to the right, in this photo is the same as your trademark logo that you see here to the right, as well as what's kind of picture here on your clothing. So again, I think if Dame Dash would have went to a trademark attorney, they would have told him that, man, you bugging out. I don't think you're going to win this. But more importantly, you see this Dasco Poppiton, which is Dame Dash business Instagram page that has been taken down or deactivated, temporarily deactivated, whatever you want to put it, which in my opinion, I think that's partially because of this whole trademark threat that he gave against Balenciaga. Somebody told him, hey man, deactivate your page, whatever the case may be. But thankfully your boy caught it. Thankfully your boy caught this thing earlier so that I was still able to kind of give you guys the latest and greatest on this. So I think Dame Dash is bugging on this one personally. But again, reasonable minds can differ. Let me know what you guys think in the comment section or in the chat with regard to whether or not you think Dame Dash is going to prevail or he's right against, with regard to his trademark lawsuit or his threat of a trademark lawsuit against Balenciaga. I think he's bugging because he doesn't own CEO. He owns a version of the logo. However, I don't think that Balenciaga CEO sweater that you see here is similar to his version of the logo. So this is what Balenciaga is selling. This is what Dame Dash has a trademark on his logo. And he threatened Balenciaga for trademark infringement. I do want to kind of reemphasize that this Dusko Poppington, which is Dame Dash official business Instagram page, that has been taken down. And it is my suspicion that it's been taken down because of the threat of the lawsuit against Balenciaga. So let me know what you guys think. Do you guys think it's a likelihood of confusion? In other words, do you think this CEO logo is similar to Dame Dash's registered trademark of CEO? I would disagree. I don't think that this, again, shout out to Dame Dash for having a trademark on the CEO logo, but I don't think that's similar to or likely to confusion based off of Balenciaga's CEO logo that they are selling on the shirts. So that's kind of my thought on that one. As we move on here to Tesla. Tesla, man, Tesla has been working overtime, man. Let me kind of bring it up. Tesla has came up, seems like, with a new patent that they filed on their Cybertruck. You see this inflatable portion at the rear end of the Cybertruck. And again, please go check out that video. It was a lot of nuggets dropped by myself in that video where I pulled up the patent application. I read through the claims, but it seems like Elon Musk and Tesla has filed for a new patent application on this kind of inflatable portion of the Cybertruck to help out with drag and so forth and so on. So typically these, I'm not sure if you guys can see my cursor, but typically these Cybertrucks, they don't have this inflatable portion. But again, to the extent that you are hauling a trailer or whatever the case may be with your Cybertruck, they have this inflatable portion that you can employ such that you can get better drag, which ultimately means better, I want to say fuel efficiency, but battery efficiency on your Cybertruck. Now, I will say, just because you file for a patent application on something or you even get a patent on it, that does not mean that you're going to put something in production. I tell people all the time when they come to me like, hey, I never seen anything like my invention. I say, man, let's do a search on this, because just because you haven't seen anything, that does not mean somebody has not tried to file for a patent application or has got an issued patent. There's a ton of stuff out there that has been filed on or issued that people just haven't put in production. So again, let's kind of do a patentability search and go from there. And it seems like in this case, Tesla has filed for a patent application on its inflatable component, I call it, on their Cybertruck. So is this a Cybertruck 2.0? I'm not sure, but just kind of keep in mind that, and I will kind of continue to bring you the latest and greatest in case kind of we look up 6 months from now, a year from now, 2 years from now, and Tesla has this kind of inflatable portion that it is kind of really implementing on their vehicle. So definitely let's kind of be on the lookout for that. And before we get to the lawsuit of the week, man, hey, this AI stuff is getting more and more scary. We talked about, obviously, AI and how that's affected businesses. You have massive layoffs across the board. We talked about the AI musicians. I think DJ Khaled or somebody had signed the first AI artist, which I think is crazy. We now have the first AI actress. Now, you guys have to let me know in the chat or in the comment section, are we that much of a degenerate society that you want to look at a show that has an AI, artificial intelligent actress? I think that's kind of crazy, man. One of the big things that I love about watching movies is knowing the actress and knowing their story, whether it's Denzel Washington, whether it's Leonardo DiCaprio, whether it's Will Smith, and knowing that this is a real person that has real acting skills. Are we that much of a degenerate society that we want to essentially follow and look up AI actresses? You guys have to let me know that in the comment section, man. That's kind of, this stuff is getting a little scary to me. And it seems like the first AI actress is has been signed, not just there. Somebody has signed this AI actress. And we're going to go to this YouTuber businessman, Anton Daniels, because I think he had some good takes on it. And I kind of want to go over his takes and let you guys know whether or not I agree with him or disagree with him. Let's see what Anton Daniels is talking about this whole AI actress. Then we're going to come to me and I'm going to give you guys my thoughts. You can tell by his facial expression, he's not too hot.
3 seasons and a podcast.
Meet Tilly Norwood, the world's most controversial new actor.
Can she cry on Graham Norton?
While she might seem real on screen and on her social media, take a closer look. Can you tell?
Tilly Norwood, 100% AI generated.
Yep, she's fake. Tilly Norwood is the first creation from a new studio that develops AI actors. And this morning, her mere existence has sparked outrage and concern about the use of artificial intelligence in Hollywood.
We have so far lost the plot. What are we
I
doing?
agree with that.
The backlash to Tilly Norwood igniting over the weekend after her creator, Dutch actor and comedian Elena van der Velden, said multiple talent agents have shown interest in signing the AI actress, according to Deadline. That news prompting real actors to speak out in protest. Emily Blunt calling it really, really scary in an interview with Variety, urging agencies to please stop. Van der Velden posting a lengthy statement defending the invention, comparing it to animation or CGI, writing Tilly Norwood is not a replacement for a human being, but a creative work.
Hey, do you guys think that the AI actress is the same as animation? I would probably disagree with that. We all know that animation is animation. We're not looking at animation and thinking that this is a real person. However, the whole point of AI, especially in this case as it relates to actresses, is kind of to give off human-like features, which I think in that vein, it kind of tricks you into thinking that this is actual human. However, it's not a human. So I definitely disagree with the whole the notion of this whole AI actress is the same as a human-like person. I mean, it's similar to animation. I disagree with that. But again, maybe you guys disagree with me. Two reasonable minds may differ. Let me know in the comments or the chat if you disagree. Let's go.
Piece of art that sparks conversation. Whoopi Goldberg among those responding.
The problem with this, in my opinion, humble opinion, is that you are suddenly up against something that's been generated with 5,000 other actors. So it's a little bit of an unfair advantage.
The debate over Tilly Norwood, just the latest in the battle between creative artists and AI. Last year, Scarlett Johansson threatened legal action against OpenAI after the company unveiled a voice assistant that sounded eerily similar to hers.
Hello, I'm really excited about teaming up with you.
OpenAI denied
This AI
modeling it
stuff
after
getting
Johansson,
crazy.
but ultimately suspended
coming
the
for all our
voice.
jobs.
And more recently, Vogue faced criticism after running an ad for fashion brand Guess that used an AI model instead of a real
Let's see
one.
what Anton says about this.
I mean, there's so many questions.
Yeah, I'm not a fan of it, but you know what? I'm gonna be honest with you.
It's coming.
It's coming.
It's coming.
It's coming. Every single day. Or I'll be honest with you. I would say, because I use AI and I'm tapped in and I've done a Patreon video and I got a new one coming out. Actually, I'm gonna just do a live stream.
Y'all about to get y'all a product.
On the improvements and then how you guys can leverage AI in order to continue to get bags. How rapidly it's improving is crazy.
AI
How
coming for all our
rapidly
jobs.
it's improving is insane. Once they start making videos longer than 8 seconds, I think it's going to be over. If they can get a video to a minute, that's it. That's it. And the Hollywood actors is upset because it's basically taking work away from them. The studios want to actually replace the Hollywood actors so that they don't have to spend as much money on costs and development costs.
And the actors complaining out there.
It's bad. It's 100% bad. I'm not a fan of it. I don't like it. Am I going to embrace it?
Yes,
Probably, because I don't really have a choice. And so that's why I'm learning everything that I can about it. I don't like certain aspects of it. I think that it streamlines your work and it helps you to create more effectively, or it could, you can leverage AI a lot of times. Some of y'all need to start using AI and Apple Intelligence to fix your text messages, because y'all be sending some crazy text messages. But it could do a lot of things. You know what I'm saying? It could schedule certain things now. It's an assistant that it could release, have text messages sit out at a certain time and all of that other type of stuff. So there is some stuff that you can benefit from, but just to remove the human element, you know what AI feels like? It's like getting into a car and it ain't got nothing but screens. It's like, yeah, that could be okay for a basic daily driver, but don't nobody want that inside of their sports car. Don't nobody want that inside of their classic. Don't nobody want that. Like, technology can remove the human element. It can remove the knobs. It can remove the manual stuff. But in my opinion, it just makes the manual stuff become much more valuable.
Here. I mean, first of all, given all the backlash, I mean, how do things play out from here? Where does it go?
On anyone suggesting AI projects as artificial intelligence again arriving sooner.
You know why they saying
Isn't
that?
that deep?
Right there? Because if you don't have a name that's recognizable, then you can be easily replaced by AI also.
That's why I preach.
Let me
this
tell you where the
intellectual
real money
property.
is going to be. The real money is going to be in making sure that you
Got a brand.
create a name and visibility for yourself to where people are paying for you instead of paying for the service that AI provides. Some people is not going to understand what I'm saying, but I'm gonna try to make it a little bit clearer for you as a C student. What I'm saying is when LeBron James endorses a product, for example, or
Y'all need to listen
when
to this.
Tom Brady
This is important.
endorses a product, for example, a lot of times the influence of that person can impact the sales of a product. You can leverage AI, but you can't sell Lamar Jackson and, you know, all of the stars and the Ja Morants and the.
So, man, I think what Anton was saying was a lot of it was good, but I would disagree with him on this. He was pretty much saying, hey, you need to be able to use your real name to leverage or pretty much to get ahead. And I do agree with him in a sense. I think that, and that's why I do this whole channel, man. Intellectual property is going to be important more now than ever, especially with this artificial intelligence, whether you have patents, whether you have copyrights, whether you have trade secrets, and whether you have trademarks are going to be more important than ever. But I don't think that, like, man, I like using my real name, David Spears. And I know Anton Daniels like using his real name, Anton Daniels. However, whatever name that you're going to use, you need to protect your name so people can associate. Number one, people can associate the name with you, and then the fact that it's protected. However, you still have a host of people, even though they're not using their real name, it's protected. So think of The Rock. We all know his name is Dwayne Johnson, but he has The Rock protected. Think of Jay-Z. Jay-Z is not his real name, it's Sean Carter, but he had the name Jay-Z protected his stage name. So whether you're using your personal name or your real name, or you're using a stage name, I think more importantly for me, you need to be able to protect that name. That's kind of what I want to say towards that. I don't think that it's Anton Daniel was saying that. And again, I do agree with him to a certain extent. He said, hey, you need to have some type of name that's recognizable to people, that stands out, that you can, so people can kind of go to you. And I do think that's important, but I don't think it has to be your real name. Whether it's a real name or a stage name, it's people who use their real name out there that got people such as Denzel Washington, Will Smith, Anton Daniels. However, it is people who use their stage name, such as Jay-Z, such as Dwayne Johnson, so forth and so on. So regardless of that fact, I just want you to protect your name, whether it's real name or your stage name by a trademark. And whatever other intellectual property you have, make sure that that's protected. I think that's going to be more important now than ever, especially as this AI stuff comes into the fold and is becoming more and more realer. So that's kind of my take on that. Let me know if you agree with me or disagree with me on that as we kind of move on to the last subject of the day, and that's the lawsuit of the week. The old school versus the new school. You have old school Louisville whiskey. Then you have new school Louisville whiskey. Seems like old school Louisville whiskey did not like the whole new school Louisville whiskey and hit them with a lawsuit for trademark infringement. Let's kind of pull that up and see what they are alleging before we get you up out of here. Looks like the Tigers game may have started already, so I'm not going to try to keep you guys that much longer, but I do think this is important to go through. So we had old school Louisville whiskey versus Keith Hazelbaker Ventures, which seems like he's trying to get the new Louisville whiskey that protected, that name protected. So let's go to the nature of the action. No, I'm going to skip that. Let's go to the parties. Old Louisville is a Kentucky LLC, its members, so forth and so on. Old school Louisville manufactures, distributes, so forth and so on, premium whiskeys and related merchandise. Mr. Corral is the owner of the federally registered Old Louisville whiskey. So it seems like Mr. Corral has that Old Louisville whiskey trademark. I'm telling y'all want to trademark this stuff. So it says Hazel Baker, who's the defendant in this case, is a Kentucky corporation with its principal place of business in Kentucky. I actually want to go to Kentucky, man. I've never been to Kentucky, but shit, it seems like shit, all the good whiskey is made. And I'm not even a whiskey guy. I'm more of a wine guy, a tequila guy at this point in life. But it seems like all the good whiskey is goddamn made in Kentucky. So Hazel Baker has thus far unsuccessfully sought for registration of the USPTO of new Louisville whiskey. And I can tell you, if the USPTO is saying that it's a likelihood of confusion or preventing you from getting your trademark in light of another trademark, that's not a good sign, in my opinion, as a 10+ year trademark attorney or intellectual property attorney. Let's get to the facts here. Mr. Corral, or the plaintiff, is the owner, and Louisville is the exclusive licensee of the valid trademark Old Louisville whiskey. Pursuant to his license, so it seems like Mr. Corral, and this is the good thing about trademarks, you don't have to necessarily, you can license it. So it seems like Mr. Corral, the plaintiff, has licensed the Old Louisville whiskey out to other people in exchange for money or in exchange for a royalty. That's pretty much what that is saying. So that's really, a good point in terms of the big benefit of having a trademark, that the fact that you can license it. So pursuant to the license of the mark from Mr. Corral, Old Louisville has the right to take such actions as are necessary to prevent infringement. So Old Louisville uses this mark in commerce throughout the U.S. And let me know if you guys have a question as I'm reading through this lawsuit from Old Louisville whiskey. So it says photographs, copies. I'm not going to go through it. You see here the Old Louisville whiskey to the right and the new Louisville whiskey mark to the left. Old Louisville mark is distinctive. Okay, that's pretty much straightforward. Old Louisville has expended substantial time, money, and resources marketing, advertising, and promoting its trademark, including without limitation, engaging with its social media, offering tastings, participating in festivals, and competing in industry competitions. You guys have to let me know in the comment section if you are a whiskey drinker. Like I said, I'm not a big whiskey drinker. I'm more so a tequila guy and a red wine guy at this point in life. Old Louisville has expended over $75,000 per year on his website, branding expenses, graphic designers, and other marketing efforts to promote Old Louisville goods and market. Now, I will say that the reason they said that is because, for those of you who don't know, when you're suing somebody for trademark infringement, that's a federal offense. That's federal law. And a lot of times, well, not a lot of times, but for you to sue somebody in federal court, the damages have to be over $75,000. So if you're trying to sue somebody in federal court, but the damages are only $10,000, you're probably not going to be able to get in federal court. However, in trademark cases, to get in, which a lot of times those are done in federal court, you have to be able to say that your damages are going to be $75,000. So that's why I think that they put that in there to say, hey, our damages are going to be $75,000, given the fact that we spent all this money on website branding, graphic design, so forth, and marketing efforts. So Old Louisville promotes its goods under the mark via its website, on print materials, merchandise such as shirts, glassware, so forth and so on. Old Louisville offers and sells its goods under the mark to consumers 21 years of age. You got to make sure you ain't selling kids the liquor, man. Man, I wish I could tell y'all something, but we on the internet. But again, obviously, at least in America, you got to be 21 years or older to buy alcohol. Old Louisville goods are the highest of quality. Old Louisville goods are aged a minimum of 7 years. God dang. That's interesting. As a result of Old Louisville's expenditures and efforts, its mark has come to signify the high quality of Louisville goods designed by the mark and acquired incalculable distinction, reputation, and goodwill. Let's go to the defendant, Hazel Baker. Without Old Louisville's authorization, and beginning after Old Louisville acquired protectable exclusive rights, Hazel Baker adopted and began using new Louisville whiskey. The old versus the new. So first, on October of 2022, so 3 years ago, Hazel Baker tried to file for a trademark application in the USPTO. Seems like on August 17th of 2023. So, almost a year later, USPTO issued and I will tell y'all, man, to get an office action almost a year later, that's kind of pretty. Typically, in trademark cases, you're going to get an office action within 6 months. Sometimes give or take a couple months. But to get something almost a year, that's unusual. Let's just say that. So the USPTO issued a non-final office action declining to register the new Louisville whiskey in light of the old Louisville whiskey mark. Seems like Hazel Baker did not respond and that application went abandoned. Again, if you don't respond to an office action by the USPTO for your trademark or your patent application, the application will go abandoned, which is what item 22 is talking about. So it seems like second, rather than respond to the USPTO non-final office action, Hazel Baker filed a Kentucky assumed name registration for a new Louisville whiskey company. I'm not sure exactly what that means. I haven't looked that up in detail, but it seems like on February of 2024, Hazel Baker filed, and they filed a petition to revive. I will say it's extremely difficult. I don't want to say it's extremely difficult. It's difficult to revive a petition or revive a trademark application. But if for whatever reason, it seems like new Louisville whiskey company, they filed another trademark application, but then they went back and tried to revive their old one, which is, it's starting to get a little interesting because it's typically not how this is done. Once again, the USPTO declined to register Hazel Baker's trademark application and issued a non-final. This time on the basis that Hazel Baker infringed a mark is confusingly similar to old Louisville's mark. And again, I'm going to continue to tell you guys, if you're trying to file for and listen close to this one, if you're trying to file a trademark application and examine that the USPTO issues you a non-final office action, this is not obviously across the board, but if they issue a non-final office action because there's a likelihood of confusion in light of another registered trademark, and you continue to try to use that trademark, you're probably going to be sued. So just kind of keep that in mind. So specifically, the USPTO explained to Hazel Baker that its infringement mark creates a similar commercial impression. So essentially, I'm not going to read all that, but essentially saying, hey, it's a likelihood of confusion between the old Louisville trademark, old Louisville whiskey trademark. The USPTO further advised Hazel Baker that where the goods of an applicant and registrant are identical or virtually identical, as in this case here, the degree of similarity between the marks required to support a finding that confusion is likely declines. It also found that Hazel Baker and old Louisville goods are legally identical in part. And pretty much what they're saying is, hey, if you got two marks, and backing up here, when you file for a trademark, you got to let the USPTO know what class you're going into. You can't file a trademark and it's protected in everything under the sun. So new Louisville, they're filing for a trademark for, the sale of whiskey, alcohol, so forth and so on. However, the old Louisville whiskey company already had a trademark for that same class. And if the only difference between old Louisville whiskey company and the new Louisville whiskey company is old and new, you're probably not going to get that trademark. That word difference better be distinctive. And to the extent that it's not distinctive, you're probably not going to get that trademark. And I would imagine that old and new is probably not a distinctive enough to get a trademark with the USPTO. Let's see here. Moreover, the USPTO concluded that the goods offered by old Louisville and Hazel Baker were provided in the same class. We went over that. In short, the USPTO told Hazel Baker that since the marks are highly similar, the goods are legally identical in part, and the goods and services are substantially related in the part that there's a likelihood of confusion. Accordingly, the USPTO refused the registration. That would be a likelihood. So essentially refused the registration. And you can see here the new Louisville Whiskey Company, which I also have here to the left. So let's hear. On January 28th, earlier this year, Hazel Baker applied with the T-tab. What is the TTB? I heard of the TTAB, the Trademark Trial and Appeal Board, for certification of another label regarding the infringement mark. The T-tab, I think that they just got this wrong. It's not the TTB, it's the TTAB, which is the T-tab. Certified Hazel Baker second label on January 29th. 2 copy. Let's see here. See, I don't like this, man. Because the reason I don't like this is they're confusing things. At first, they were talking about a word mark. Now they're talking about a logo. Whatever. After securing a 3-month extension of time to respond to the USPTO, Hazel Baker pushed back on the USPTO's second non-final office action via response dated in February of this year. Therein, Hazel Baker advised 2 key arguments. First, that its infringement mark differs from old Louisville mark in appearance. Again, that's the whole point of a logo. So they're not trying to trademark the word mark, new Louisville Whiskey Company. Now they're trying to trademark the logo. But it seems like in this case, the USPTO still rejected them, saying that, hey, your logo is a likelihood of confusion with new Louisville. Well, you can tell that the examiner did not want to trademark this term. Instead of old A second Old Louisville federally registered mark is commercially weak. In its most recent non-final office action dated in March of this year, the USPTO maintained and continued its refusal. Like I said, that examiner did not want to file for it, not want to register this trademark, not want to allow the trademark, I should say. At the onset of its notice, the USPTO set forth the principles informing its decision. The question is not whether people will confuse the marks, but whether the marks will confuse people into believing that the goods and or services they identify come from the same source. Thus, the proper focus is on the recollection of the average purchaser who retains a general hey man, people just trying to get their whiskey. Applying those principles, the USPTO explained to Hazelbaker that even if potential purchasers realize that the apparent differences between the marks, they can still reasonably assume, due to the overall similarities in sound, appearance, connotation, and commercial impression in the respective marks, that Hazelbaker's goods and services provided under the new Louisville Whiskey Company mark constitute essentially a likelihood of confusion in light of the old Louisville Whiskey Company. In closing, the USPTO explained that its overriding concern is not only to prevent buyer confusion as to the source of the goods and services, but to protect the registrant, Old Louisville, from adverse commercial impact due to use of a similar mark. In spite of the USPTO persistent refusal to register Hazelbaker infringing mark because it's confusingly similar Old Louisville mark, Hazelbaker has distributed. So look, I will tell you guys this. This is kind of unusual. Typically, you'll file for a trademark and the USPTO deny you. You probably either respond to it or you try to change course. The fact that the defendant, Hazelbaker, tried to file another trademark application, then tried to file a third trademark application on the logo, that's unusual. And the fact that the USPTO continued to deny it, that doesn't bode well for Hazelbaker, in my opinion. So in spite of the USPTO persistent refusal to register Hazelbaker's infringing mark because it's confusingly similar mark, and the fact that they continue to sell the mark, distribute the product, so forth and so on, that's not a good sign. You see the new Louisville, and this is probably why they tried to continue to file the trademark, because all this stuff was in means for production. So you see here a picture of the new Louisville Whiskey Company bottles, which the USPTO said that you're not going to be able to register mark in light of the old Louisville Whiskey Company. And like I said, I'm not a whiskey man myself. I'm more of a tequila and a red wine, but I think the USPTO got it right. Let's finish up here. Relatedly, the Hazelbaker is engaged in a manufacturer, that's whatever. As predicted by the USPTO, Hazelbaker's infringing acts have caused and are likely to cause confusion, mistake, and deception among the consumer public. In fact, Hazelbaker's infringing acts have resulted in actual confusion. The best thing you can have from a lawsuit perspective is actual confusion. Old Louisville customer believing that Hazelbaker's goods were actually, let's see what they say here. Okay, we have Nick Hayden. Not here to start drama. And anytime you say you're not here to start drama, you're probably here to start drama. However, I'm well aware of branding, trademarks, and other legalities around the business. Not sure if you are aware of this, but New Louisville Whiskey Company is eerily similar to your brand. And it seems like Nick, hey, at least within the African-American delegation or culture, we don't like tattletellers. And it seems like Nick is tattletelling to Old Whiskey Company. Now, whether or not Nick is a Old Whiskey Company has told him to do this, I don't know. But it seems like he sent Old Louisville a DM on Instagram, it looks like, back in October of last year. What he said, I do believe in protecting one's brand and eliminating confusion between likes and prices that could. Man, I think this is a paid guy, because typically the consumer confusion, maybe they say, hey, this looks similar to Old Whiskey Company, but all this commentary seems like this is a paid, in my opinion. I'm just giving you guys my take on it, based on growing up in the streets of Muskegon, Michigan. It seems like Old Louisville put your boy Nick up to this. Additionally, on August of this year, so a couple months ago, Old Louisville received a call from a confused Hazelbaker customer. The customer called Old Louisville to ask about Hazelbaker's release Cream Brulee, sold under the new Louisville mark. Old Louisville advised the caller that Hazelbaker is unrelated to Old Louisville, and the customer was perplexed. Yeah, it seems like Old Louisville is, at least in my opinion, getting paid customers or getting paid people to call in on behalf of them. Hazelbaker acts were willfully made with the deliberate intent to trade on the goodwill of old Louisville in his march, cause consumer confusion, so forth and so on. Hazel Baker acts are causing and unless restraint will continue to cause damage and immediate irreparable harm to old Louisville. His valuable reputation and goodwill with the consuming public, for which old Louisville had no adequate remedy of law. Seems like it was a cease and desist letter. And I'm not going to go through that because we are running out of time here. So what do you guys think? Again, I do think that the USPTO got it right in this case as far as saying that the new Louisville whiskey trademark is the likelihood of confusion. So I will give it to old Louisville on that, as well as the USPTO. I think they got this one right. But in terms of the whole actual confusion is the best type of confusion that you want. But kind of based on those examples, it seems like kind of Nick and the caller was kind of put up to it based on kind of, I'm just giving you guys my street intuition on this. Well, maybe that's not the case, but I'm giving you guys my street intuition. So let me know what you guys think in the comment section. And again, we went over a lot today. We went over Dame Dash. We went over the AI actress. We went over Shark Tank starting back up in that Shark Tank breakdown of the week. We went over Elon Musk and Tesla Cybertruck. They have a new patent that they file on a new Cybertruck. So definitely go check that out. And last but not least, Super Soaker, the interview of the week, Lonnie Johnson. Please go check out that. That is a banger. So yeah, that's pretty much all I have for you guys. Like I said, we have the Detroit Tigers playing today. We have Sunday night football, I should say. So I don't want to keep you guys from paradise. I did just want to bring you guys the latest and the greatest on the IP recap of the week, as well as the lawsuit breakdown of the week. Hopefully you guys enjoyed this one. Please hit that like button for the YouTube algorithm, as well as hit that subscribe button to be a part of the IP community. And I will see you guys next week. Bye-bye. Take care.